When we talk about deregulation, we often think of some license, approval, permit, some compliances or the red tape. But I'm going to talk about deregulation in a slightly different context. I would like to call it de-judicialization of the dispute resolution process. So in a purely commercial, private commercial world, private parties would opt for, let's say, an arbitral institution to resolve their disputes. Why? Because institutional arbitration is way more efficient. It's neutral, it's credible, and it has streamlined rules. But the problem arises when one of the party is a central or a state PSU. The contracts they have clauses insisting on ad hoc arbitration. And typically they would have a senior bureaucrat or a retired public official who will be appointed as an arbitrator. Now we know that these clauses have been challenged and the courts have invalidated these clauses for want of neutrality. Okay. So then who appoints the arbitrator? So parties have to then approach the courts, and the court would typically appoint retired high court judge as the arbitrator. The problem in such cases is then who would hold the arbitrator accountable, right? In ad hoc arbitration, these are, per hearing basis fee arrangements. And so it's in the interest of the arbitrator to prolong, and also the interest of one of the parties to prolong the arbitration, and hence these sort of arbitrations are often delayed. And when it is delayed, the law provides for a statutory timeline of 18 months. And when it crosses that, parties have to go back to the court for extension, because you can't extend arbitration without the permission of the court. So you have to go back to the court. And as per the law, the court has to then do fault finding. It has to ascertain who was responsible for the delay in arbitration. If it is the arbitrator, the court would impose, have some fee cut. If it is one of the parties that is responsible for delay, the court would impose cost on that party. What our research finds is that the court doesn't do that. Why? Because the court knows that if it tries and do that, then it would take another maybe 2 years to find fault and ascertain who was responsible. So in the first hearing itself, most judges would pass orders by consent of parties and they grant extension. So basically what was supposed to be a justiciable or a judicial function, it is converted into an administrative function. So these are two touch points. One is the appointment of arbitrator and the other is grant of extension to continue with arbitration proceeding. And both these touch points with the judiciary are either managerial or administrative functions. And the question I ask is, should judiciary take up these functions, right? And so this is unnecessary. It takes up more time. And so the parties really gain nothing. Both the points don't really add much value to the process of arbitration. So what is the solution? The solution that we propose is that the state should amend its contract and should switch from ad hoc arbitration to institutional arbitration. What it means that it should look for a private arbitral institution that provides for neutrality, efficiency, and is cheaper than ad hoc arbitration, because mostly it charges for a lump sum fee, and the fee is often in long term is actually cheaper than ad hoc arbitration. And it's not a trivial matter, because trillions of rupees are locked up in disputes pertaining to public procurement, right? Not only this would usher in those huge quantum of amount or money which is locked up in dispute, but also ensure ease of doing business for private contractors. All the state needs to do is to switch from ad hoc arbitration to institutional arbitration. That would mean going for a private arbitral institution that can ensure neutrality, credibility, efficiency. It is likely to be more cheaper than ad hoc arbitration. What it does is that when parties haven't really thought about arbitrator, or if they have put that arbitral institution in their contract clause, they will go and approach that institution, and the institution will then appoint a suitable arbitrator, which means that they don't have to go to the court. And institutions are much faster. They might provide for an arbitrator maybe in a week or in a couple of days. It can be as fast as that. Second is that there may not be any need for extension because institutions can be very fast. One of the institutions' data shows that 91% of their arbitrations are wrapped up in less than 18 months. So what the state needs to do is to switch from ad hoc arbitration to institutional arbitration.